In today's video, I'm going to tell you the story about the case of Lambert and Roberts of 1981, which many of you may think of as something of a loophole. But first of all, if you're new to my channel, make sure you hit the subscribe button and that bell icon and turn on the notifications so you receive new video notifications. And if you found any of my videos useful, please do share it with somebody that you might think would find them useful. You never know when they might help in their hour of need. So this case was about the offence of failing to provide a specimen of breath, and the defendant was ultimately acquitted. But it's how he was acquitted that makes this case so interesting and how many people might think of it as something of a loophole. So let's start with the law. Section 8 of the Road Traffic Act 1972 provided that a constable in uniform may require a person driving a motor vehicle on a road or other public place to provide a specimen of breath for a breath test, if the constable has reasonable cause to suspect him of having committed a traffic offence whilst the vehicle was in motion. And under subsection 3, a person who without reasonable cause fails to provide a specimen of breath for a breath test under subsection 1 shall be guilty of an offence. At 12 minutes past 11 in the evening on the 29th of May 1980, two police constables were driving along the A507 in Bedford, whereupon they appeared behind the defendant, Mr. Roberts' vehicle, a Ford Escort, and they noticed that he was driving at 60 miles an hour when the speed limit was 40. After a short distance, the defendant made a left turn and then turned right into his driveway. The police officers had followed in their vehicle, pulled up outside, and got out and followed the defendant onto his driveway on foot. One of the officers told the defendant that they'd observed his speed at 60 miles an hour when the speed limit was 40. And the defendant was then cautioned by the police officer. The defendant responded to the police officer to the effect that he was trespassing on his land. At this point, the police officer noticed that his breath smelt strongly of alcohol and told him that he'd just committed an offence and was required to provide a specimen of breath. Initially, when asked, the defendant said yes, he would be willing to provide a specimen for a test. The officer asked him whether it had been at least 20 minutes since his last drink, and he replied, no, it's only been about 10 minutes. So the police officer said, we will wait for the full 20 minutes before conducting the test. All right, the defendant said, but I want to make a telephone call to my solicitor first because we're on private land and I want to know that what you're doing is correct. The officer agreed to the telephone call provided that he could follow the defendant into his house, obviously to watch what he was doing. Once a further 10 minutes had elapsed, i.e. 20 minutes in total, the police officer said 20 minutes has now expired and you are required to take the breath test. The officer offered the defendant the breath test and advised him of the consequences of failing to provide it, and asked him whether he was willing to provide it. The defendant said yes, but not before I've received my phone call. The officer offered the breath test again to the defendant, and again he refused, making reference to the fact that they were on private property and effectively trespassing. At that point, the officer advised the defendant that he was being arrested for failing to provide a specimen of breath for a breath test. Just at that moment, the telephone rang, and as the defendant rushed to answer it, he was stopped, arrested, and handcuffed. During the arrest and at various times, the defendant's family were protesting that he was being asked to provide a specimen of breath whilst on private property. The defendant was conveyed to the police station and again asked to provide a specimen of breath or blood or urine. A couple of requests were made, but the defendant refused. At 35 minutes past midnight, the defendant, having refused to provide each specimen, was formally charged. He answered no to each charge and was bailed to appear at the magistrate's court. However, when Mr. Roberts was produced in court, the justices were of the opinion that the police officers were trespassing on Mr. Roberts' land because he had asked them to leave, and at which point they should have withdrawn immediately. Therefore, the justices were of the opinion that the police officer had acted unlawfully in requiring Mr. Roberts to provide a specimen of breath, and in arresting Mr. Roberts and requiring the laboratory test. The prosecutor contended that the arrest in the defendant's home was lawful because they'd followed him home and had suspicion of a road traffic offence, and since that he smelt alcohol on the defendant's breath, that it was proper that he was required to provide a specimen. However, the defendant contended that the issue in this case was whether or not the officers were really allowed to demand a specimen of breath, since they knew full well that they were on private property when they required it. He contended that he objected to providing the specimen because he believed they had no right to acquire it, and that it was clear to the officers that he had refused on that basis from the moment they arrived. Further, that it was increasingly clear that he objected to the police officer's presence in his private home, and finally that the principle in another case, Morris and Beardmore of 1980, must be applied in this case. The prosecutor appealed by way of case stated to the Queen's Bench Division. This means they set out the facts of a case and put the question to the court to answer, to determine whether it was right or wrong. Following the facts, the question for the opinion of the court was twofold. One, whether or not the police officer's license to be on the private property had been revoked during the time that they were there, whether by the defendant's initial statement and reinforcement thereafter, making the police officers trespassers on his property, and secondly, whether the justices were right to apply the principle in Morris and Beardmore to this case. That principle being where a police officer loses the right to require a breath test when the license to be on private land is revoked, and remaining there would make him a trespasser. Lord Justice Donaldson and Mr. Justice Brown considered this case in great detail and found as follows. On the one hand, whilst it is settled law that a police officer can require a breath test off the road, provided that there is a chain of events and they've effectively followed the vehicle off-road when the breath test is requested. However, the problem in this case was that by the time the police officers approached the defendant, he was already on his private property, and so the first question to answer was whether or not the justices were right to conclude that this license, this permission to be on the defendant's private property had been revoked from that point onwards. The court said that on the one hand, in the absence of a locked gate or a sign that said "police keep out", then police had just as much implied right of access to the property as any other citizen with genuine business with the occupier of that property. However, that such a license or permission is also revocable, can be taken away, with immediate effect and without prior notice. In this case, the court noted that the justices had found that such license was revoked by the defendant's initial statement that this was private property, rendering the police officers as trespassers. Further, that once this license had been revoked, the police officers were under a duty to immediately withdraw from the defendant's property. And if they did not do so with all reasonable speed, they would not thereafter be acting in lawful execution of their duty. But having answered that question, the court still faced the question as to whether or not the police officers were still entitled to require a breath test. However, after much discussion, such as whether or not the property was that of a third party, the court decided that the decision and principle in Morris and Beardmore must apply to this case, and therefore it was private property and the police were not entitled to request the specimen of breath because they did not retreat from the property when they were immediately told they were trespassing. And thus the justices were correct in that the request for a breath specimen was not lawfully made. That being the case, both the arrest and subsequent requests for specimen of breath, blood and urine were also rendered unlawful. Therefore, and accordingly, the defendant was entitled, as a matter of law, to be acquitted of both charges of failing to provide a specimen. So as you've heard me say in many videos before now, it is absolutely essential that you get formal legal advice, because one small twist in this scenario had allowed this defendant to effectively escape prosecution. Now, I am not saying in any way whatever is it a good thing to escape prosecution when someone is actually guilty of an offence. However, the system and the law must be fair and each principle applied properly in each case. And in this case, because the request was made on private property, but the officers were put on notice and should have left, the request was rendered unlawful. So I hope you enjoyed the story of Lambert and Roberts. Make sure you also check out Black Belt Secrets, where I answer your questions in the comments. And in the meantime, thanks for watching and I'll see you next time.